All right, guys, let's get started. I know everybody's time is valuable. Welcome to our next edition with Legalese with the Ladies. I am Sean Whalen. I'm one of the co-founders and CEO of HopSkip. For those of you who might not be familiar with HopSkip, we are a platform that professional meeting and event planners use to source and contract hotels for business events, room blocks, conferences, incentives, all get sourced and contracted on our platform. And we also work with a ton of hotels. So topics that are discussed during these webinars are super important to us since we facilitate this work process. I'll pass it over to my host, Barbara Dunn. She can introduce herself. Barbara.
Thank you, Sean. Good day, everyone. Thank you so much for being with us. I'm Barbara Dunn. I am owner of my own firm as of a year ago now, Barbara Dunn Law, based in the Chicago area. I represent clients across all sectors, primarily nonprofits, trade associations, and the like, and in connection with their meetings, events, and conferences. So happy to be a part of the industry and of HopSkip, and also happy to be co-presenting once again with my good friend, Kelly Bagnall.
Thank you so much. Howdy from Texas for all of y'all who don't know where I'm from. We are also overcast and yucky here today, but not nearly as cold. I'm a partner with the law firm of Holland & Knight, and my practice is predominantly representing hotel management companies and owner groups. Many of those issues fall under the umbrella of overall operations, but also include a great deal of group sales agreements. And I'm thrilled to be here. So I think we're ready to move forward.
Thank you both. Before we jump into the content for today, just a quick reminder, disclaimer, this information presented is for general informational and educational purposes and does not constitute as legal advice. Please always consult your attorney. This is purely informational and educational. We're going to start with a poll. To kick it off, we would like to do a temperature from the audience and understand what's your big concern today with event contracts. And it should be a poll for the audience.
Is everyone putting all of the above? Yes.
I'm not seeing a result.
Oh, well, it looks like all of the above is rating high at 71% or 75%. So I think our list rung a bell.
Interesting. Yeah. So I can't see if they're still trickling on there. They start coming in.
Pretty much, I think we've got it. So we're between cancellation policies and all of the above, with all of the above prevailing.
All right, then you're in the right place. Let's pass it over to Barbara and Kelly. We're going to talk a little bit about commissions and rebates.
Great. Thanks, Sean. And yes, we definitely rang the bell, I think, with the topics, as you mentioned, Kelly. And just to set the stage for today, we picked 2 or 3 topics that Kelly and I are going to talk through at the outset that hopefully resonate with you and some of the issues that you might be encountering on the group or the hotel side. And then we'll launch into some of your questions. Please feel free, as typically you all do, to add questions into the chat. We'll take as many of those as we go today. So today we want to focus on a little bit commissions and rebates. This is an opportunity for us to kind of set the stage from the group's perspective and the hotel's perspective. And just to let you all know, there's a wealth of resources on the HopSkip website, but also in YouTube. If you look for Legalese with the Ladies. And years back, Lisa Devlin and I did a video on commissions and rebates. So if you want a deeper dive, go to that video. It's an oldie, but I think it's still, Sean, as you mentioned, a good resource for folks coming in and looking at the issues at hand. So from a definition standpoint, a commission is a charge the hotel pays to a third party in order to essentially compensate them for the placement of hotel rooms or the sale of hotel rooms. A rebate is typically a fixed price that's added onto a rate or part of a rate that's typically paid back to the group in order for the group to fund certain expenses associated with its event. So just to kind of understand the difference between the two, I sometimes hear clients talk about the terms interchangeably, but I think most of you know they're very different from one another. What I'll say from the group's perspective, both a commission and a rebate can be very valuable tools to fund or finance important functions for the meeting and event. That could be the convention center rental, it could be transportation costs, whatever the case may be. The concern I typically have is that when a group might engage with a third party to undertake a search for hotels, for example, often there is either not a contract at all between the group and the agent or a very loose contract between the group and agent. In other words, it's not clear how that agent's to be compensated. And if typically the case that the agent might be compensated solely by way of the commission, then that obligation rests with the group. And the concern is when we get to the group sales contract around the language in the hotel contract, because typically that agent is going to be named, maybe their IATA number added to the clause to say that they're a recipient of a commission, and then typically talk about a percentage of total room revenue, for example, that might be paid to that agent. So Kelly, from my perspective, I understand why often in that same clause, the hotel would want to be protected if there's a dispute between a group and its agent. And I'm seeing, and maybe those also participating in the webinar are also seeing more robust language, if you will, around the commission piece when it comes to the group sales contracts.
So to start there, I agree with you. Hotels have concerns when we see group contract language that says, for example, that the agent has earned their commission when the contract is signed, or when it says it's non-transferable. And the reason we see concerns there is because I've had lots of groups over time change their mind and want to move on to a different agent. And that puts the hotel in a bit of a pickle when it comes to the contract language. The hotels are Switzerland. We don't want to be in the middle of a fight between you and your agent. And so what we will do frequently as the hotelier is we will throw up our hands and either put the money in the registry of the court, let y'all fight it out, or we're not going to pay it until y'all resolve it. We get something in writing where everyone agrees how to resolve it. So I have a couple of issues because many of the times you're using agents for 5 to 10 different functions, not the least of which is sourcing and helping enter into the contract. But then they have 10 other things that they're going to do for which you think the commission is going to satisfy their fee. And so if you fire them, then where does that leave you? And so those are the kind of issues that come up with the clause that Barbara was referring to. But hotels obviously have other issues with commissions. So we will only pay commission on the group rate, on the group block, unless you negotiate different language for people that go around the block, and we're not going to pay 2 commissions. So if someone else is already getting a commission, or if the rate is less than your group rate, you may not be entitled to or be able to negotiate a commission on those folks that go around the block. Also, we're only going to pay if we've been paid. So if there's a bunch of chargebacks, for example, from your group on the rate, we're not going to pay a commission on something that we actually haven't collected. And then also there's an issue within the industry on whether or not we're going to pay commissions on attrition damages, on cancellation damages, on no-shows. Those are all issues that I would say are unsettled unless you've negotiated those in your contract. In my mind, when you ask for an audit provision, for example, there's a bunch of issues that come up with an audit provision, not the least of which is whether or not you're entitled to an audit for folks who are your attendees. And did you seek the right language from them authorizing us to disclose that type of information? So in my mind, rebates, commissions, and then rebates, and we'll talk a little bit on rebates and my concern on disclosures and notices. But basically when we come back, and of course the commissionable rate is net of rebate. And we have groups argue with us on those types of issues all the time. So Barbara, I'm sure I've missed about 10 different things in our discussion, but I think I hit your question.
Absolutely, Kelly. No, and it's helpful to have that perspective. So as with any clause in the hotel contract, making sure you understand the different components of the clause is important. So talking about who the agent of record is, talking about what basis the commission will be calculated. So again, whether it's the percentage and then on what, and you make the point about what rooms would be subject to commission, group rate or higher, not commissionable to another party. Make sure that language is clear. And then typically, as you mentioned, Kelly, the language is going to say commission's not subject to cancellation or assignment or transfer unless the agent consents to that. And I know from the group's perspective, that can be incredibly frustrating if it has a problem later with an agent it hired and it wants to part ways. There is that entanglement. So I can't emphasize enough to the groups, the meeting professionals on our webinar today, make sure you have a contract with your third party so you understand how they're compensated. But also, like every contract, like every meeting, you need to know where the exits are. And exits in a contract, we do a contract, we think everything is going to be wonderful, but we also have to plan that it isn't wonderful. We might have to exit. So I can't emphasize that enough. I think that's a source of a lot of entanglements in the hotel contracts on commissions. Now, shifting over to rebates. Rebates, as you mentioned, Kelly, is that add-on, and typically before a commission is calculated, a rebate would be deducted. Rebates could be set up there per night. They could also be set up per reservation. And you mentioned generally, Kelly, the concept around the audits. And obviously, verifying information after a meeting is important. And whether we call it an audit or we call it something else, I think both hotels and groups understand that we need to calculate these, obviously, based on the data that's received. So rebate calculations, that's obviously going to be dependent on it. Certainly rebates from the hotel's perspective, and I'll let you chime in more on this, Kelly. It's important from the hotel's perspective that the groups are disclosing a rebate to their attendees. And so often there's language in the hotel contract that requires the group to make disclosure. Now, whether the group needs to legally make a disclosure is certainly something that you'd want to talk to your legal eagle about. But in most instances, groups within their materials for their annual event, meeting, et cetera, will put language in the materials that refer to the fact that a portion of the hotel rate will be used to fund, for example, rental of the convention center or offset convention costs and so forth. So often the disclosure isn't, for a lot of groups, a big deal. It's typically something that it might do anyway. But Kelly, I know from the hotel's perspective on the rebates, disclosure is among the key issues.
Absolutely. And most hotel contracts will include a provision that says you, the group, you're going to decide legally whether you have to or not. But notwithstanding your decision, you're going to indemnify the hotel and defend us if there's ever a claim raised that you chose wrong on your the way you disclosed it, or if there's some kind of action that comes from the fact that there was a rebate paid. That's not our fight. It's not a hill we're going to fight on. We're going to have you indemnify us and you take care of that. And then I wanted to address, Joan, of course, asked a question and about contracting for these types of what's in, what's out, and what gets rebated, a rebate on, and what gets a commission on. In most instances, hotel contracts will address what is included. And there's some instances where you may ask questions about what is excluded. But most of the time, the hotels are very specific about what is included for commission purposes and rebates. But there's not a lot of time spent talking about the negative, if you will. So we will tell you, you get a commission on X, Y, and Z. If you want to address A, B, and C, that's something you need to bring up and address and perhaps negotiate.
When a planner or a group essentially disclose or request a commission from the hotel, and what part of the process is that typically communicated or you suggested to be? Like, is that an RFP process, or is that by the time you get all the way through making your short list that when you warn hotel?
I don't know,
I will
Sean, if your questions were, oh, sorry, Kelly, just so related to the whether the rate will be commissionable, which I certainly think if that's being sought, that should be clear in the RFP. In terms of disclosure of commissions, Kelly, I don't believe the hotels have been explicit about that requirement as much as they have been on the rebate.
Correct. It's a rebate driven analysis for us.
Great. But so in terms of requesting commission, you would say at the RFP level?
Oh, absolutely.
Yeah.
The hotels need to know if you're requesting a commissionable rate up front.
Right. All right, awesome. Let's go to the next topic for the sake of time, which I know is codes of contact. Do you want to take it away?
Yes. So this, I wanted to add this, and I'll tell you why. We are receiving from groups left and right requests that hotels adopt their company's code of conduct. So just so you know, every hotel chain that I work with has their own code of conduct. And so when you make a request to adopt yours, you're asking us to basically override our standard code of conduct that we've trained our employees on, that we gauge their performance on, and instead replace it with something that we had no aspect in creating it. And it doesn't, our hotel world has perhaps different issues and different focus, although we all want to comply with the law, different focus on how we create our code of conduct and what is important from a corporate perspective to us as far as how we rank those types of things or how we report those types of things. So just this week, I received a 178-page code of conduct. And I will tell you that it would have overridden and been, it would take us years to train our staff on what that actually meant. Hotels don't accept other people's codes of conduct, at least not knowingly. Sometimes it gets hidden in a link in some document, but hotels can't do it for the reasons that I just expressed. One, we have our own, and two, that's not what we train our people on. I will tell you generally a code of conduct from what I've seen is a detailed version, a detailed expression of compliance with the law, right? If there's a environmental requirement, then it's a legal requirement and we comply with it. If it's an HR requirement, it's a legal requirement and we comply with it. And so while I think codes of conduct are nice from a both aspirational and a guidance perspective, it's not something that I would see imposed or that I think should be imposed within a hotel contract for a hotel that's hosting your meeting to have to accept or deny or reject. When we look at kind of the buckets, if you will, under codes of conduct, and I mentioned a few, HR is a bucket. What are your HR policies? Again, environmental. What are your environmental policies? Just because you have your own environmental policies doesn't mean the hotel would. Then, of course, there's privacy and data. That's certainly a bucket. That's typically negotiated already in the hotel contract as it is. And so I just throw that out there that most of the time, while there may be internal people within your organizations that think it's a great idea to slap a code of conduct on the back of every hotel contract, it doesn't work from an operating perspective. Barbara, what did I miss?
Kelly, I can't emphasize that enough. And we use that term, sort of slap it on the contract, just kind of when we talk about, addendum coming on, right? You slap it on, it's going to fix the contract. Putting a code of conduct, while it might be a company policy to try to do, it doesn't fix the issue. It doesn't fix the problem. So I've encouraged groups, and groups, by the way, a lot of association groups, for example, have their own codes of conduct for members, but also when they're working with a sponsor or members, they're often presented with that sponsor or exhibitor's code of conduct, and perhaps similar in page length to what you described, Kelly. And often I'll say to the client, can you follow these? And often it's, no, I can't. Or some of it, as you said, Kelly, I think rightly so, are expressions of the law. So, for example, prohibited conduct when it comes to harassment and so forth. So all that I think is very important. From my standpoint, the key is for the group and the hotel to have a discussion. If that group said, if you said to that group, okay, out of 178 pages, pick your top 5 issues and let's talk about them. And you talk about them and you say, well, our code's similar and this is what we do and this is what they do. At the end of the day, the whole reason you have the code, presumably, is so it will be followed during the meeting. And that means education, that means training, that means awareness building. So putting it in a contract and then later saying, oops, I got you because you didn't follow this code isn't the purpose of those codes. The purpose of the code is certainly to ensure that the meeting is performed, the services are provided, et cetera, in compliance with what both parties expect, whether it's personal conduct, misconduct, whatever the case may be. So my recommendation to groups, well, I think it's very important for groups to consider having, for example, a code of conduct for its event, how folks behave and what the rights are if they don't behave and so forth. I think when it comes to hotel contracts, and I see this with hotels saying to groups, we want you to follow our code of conduct. As you said, Kelly, it isn't one size fits all, and slapping it on isn't going to make it happen. So I think before both parties agree, and certainly this is true with any document that's linked in the contract, linked meaning, have a hyperlink that you could click on. If it's not attached, I'm always concerned with any kind of linked contract that the group isn't seeing it, reading it, and incorporating it into the contract as it exists at the time the parties sign the contract. Because, of course, if it doesn't exist that way, it can change, of course, in what it says on the link. But I think overall, my concern on the codes of conduct is just making sure the parties are going to follow any codes of conduct that are critical to them. And from the hotel standpoint, Kelly, just to toss it back to you on that point, I would, as you've said oftentimes, everything in a hotel contract is a business decision. But for this particular hotel or this particular chain, I have to believe that if it's take it or leave it, if you want our business, it's 178 pages. It is truly, truly a business decision that's going to affect presumably maybe other brands that may be in that same portfolio, right? From being bound to those codes of conduct.
I think, Kelly, look, you're muted at the moment. You have to click the mic icon at the bottom left.
Apologies. I don't know how that happened.
Okay.
Can you hear me?
Yep.
So
Okay.
I absolutely agree that we have to have a discussion on these things. I will tell you, for the people on this call, most big brands' codes of conduct are on their website. So if you want to read a code of conduct with someone that you're thinking about sending an RFP to, for the brands, they're there. You can go see what those are before you do business with them if you want. Joan brought up a good point in one of her comments, is that you are contracting not necessarily with the brand, and it may not be a brand managed hotel. You're typically contracting with the owner entity, and the owner entity could just own the dirt. That's other questions you might want to ask. Does that owner entity have its own code of conduct that might be on a website? I don't even know where it is because it's the owner entity. But if it's managed by a brand, that means that brand's employees are the boots on the ground, and their code of conducts are online.
Yeah. And just to also pick up on another
Barbara,
question.
what else should we talk about?
And just also, in the chat is about links themselves. How could they be legal if the information can be changed? So any document can be incorporated by way of a reference in a contract. So if I say the hotel's policies and procedures are incorporated and made a part of the contract, and it's a link to the policy and procedures, that link and what's at that link, of course, can change at any time. So if the group agrees to just that very link, it's taking the risk. Yes, by reference, those policies and procedures are absolutely, the group is bound to that, no matter what it says and change later. Now, from a best practice standpoint, I would always recommend to clients, go out, get a copy of the policy procedures, or in this case, the codes of conduct, et cetera, and review them and attach them to the contract versus allowing it to be a link, which could be changed instead of a found at, it's as attached, hotel policy and procedures as attached. That way you have your benchmark for today versus what those policies and procedures might look like tomorrow.
That's good. As always.
I completely agree with Barbara on that point. So,
Anything else to that, Kellen?
all right.
Junk fees, our favorite topic.
No,
Do you want to pick it up, Barbara?
I'm sorry.
I think we're a little delayed, so I'm not sure if you're hearing what I'm saying, Kelly.
I can hear you.
Okay. You
So-
want to pick it up?
Can you hear me?
Yeah.
I tell you what, current status of junk fees. So just so we all know, there's obviously a federal FTC regulation on junk fees. We've talked about that before. Happy to go into that in detail, but I really wanted to focus on today to let you know that the legislation is pending in many, many places. I've listed the pending legislation. We already have passed ordinance for New York City, now New York State. And then all these others that I've listed. And the reason why I wanted to bring this up is because, and Barbara will talk a little bit to this as well, when you're looking at making sure you're communicating to your attendees and you're sharing a rate with them, for example, for your meeting, you're going to want to make sure that when you're doing that, you're in compliance with the junk fee laws. So you're basically quoting all in, and depending on, and you want to make sure that you're looking at the harshest statute, because if you conform to the harshest statute, the most inclusive statute, and you adhere to that, you should be hitting on all the rest, right? But I thought it was interesting. We had some failed legislation. And so I wanted to give you a little guidance on you. And by the way, these junk fee laws impact attendees coming to your event from any of these states where they're coming from. If they're from, for example, the state of Arizona, then the state of Arizona junk fee law pretty much says, if you're inviting our person, you adhere to our laws. And so, but in Utah, it was very interesting that it did not pass. And it did not pass, not because everyone thought it wasn't a great idea. They thought it was a great idea. It got support in the House, but then it got buried in the Senate. And so when it ultimately did not pass because of legislative trickiness, not because of the content of the statute. So that will probably be reinvigorated in their next session. And I think you're likely to see a pass. Most of these other places, they are passing, and they're all inclusive of when you're giving your pricing to your attendees. And if you're the hotel, if you're posting it online or whatever, you're providing the total price. That includes any mandatory fees. It does not include taxes or government fees, but includes other mandatory fees. And if it includes, for example, a mandatory resort or destination fee, you're describing what's included in that fee and the benefits that come from those attributes. So if any of your organizations are providing information like that, versus using a hotel's link, which for reservations online where they've already got it spelled out, make sure that you are in accordance and in abeyance with those junk fee laws. And that's, Barbara, where were you? I know that you have folks that deal with some of this on your side regularly. So I think we hit on most of it.
Absolutely, Kelly. And thanks for sharing the
Did I lose
update.
Barbara?
Again, I think this is something that we see, again, as we talked about previously, junk fee laws are, to your point about what happened in Utah, so things everybody can understand and get behind. It may be procedurally, unattractive depending on how that played out there. But we're going to see more of these. And I think the assumption is to say that these laws will likely apply across 50 states and to comply as such, even if right now it doesn't. But let me say, on the point you made about the mandatory fee, commissions and rebates we were just talking about, those are not considered part of the mandatory fees. It's considered a business arrangement that's unrelated to the fee. So I think that's first and foremost for groups to understand. So second, I would say, to emphasize the point you made, Kelly, how these rates are promoted by the group becomes critical, because if the group isn't complying with the junk fee laws, it can set everybody up for failure. So using a hotel's link, as Kelly mentioned, for registration that would properly display the rate is one strategy. If you're working with a housing company and provider, find out what they're doing to make sure there's compliance. That's going to be important. And the last thing I'll say is a lot of you might have or negotiate sort of lowest rate clauses in contracts. And dispute has come up a few times now with some group clients that says, as it speaks to the rate, right, the lowest rate, are we speaking of the so-called base rate, right, before all those mandatory fees? Or are we talking about the bottom, right, the net rate? And there's a lot of situations because of the variance, right, with those mandatory fees, that if you're trying to enforce a lowest rate on the base rate, and the other party's saying, no, it's the bottom, it's all-in rate, there could certainly be a dispute. So I just caution groups to consider this, and obviously on the hotel side, consider this possibility and make sure language in the hotel contract. This is just one example, Kelly, you and I encounter a lot. There are provisions in the hotel contract which are inconsistent with one another to some extent, or set up a natural dispute. And it isn't, of course, until the dispute comes out that we realize that inconsistency. So again, I caution to always, it isn't just about the clause, oh, use this clause or use that clause. It's how that clause might impact other clauses in the contract. Why definitely I'd want folks to always understand these clauses before they put them in and train their teams.
Absolutely. All right.
Jump into some of our questions.
I'm sure y'all are junk feed out.
Yeah. And yeah, please put your questions. I think there's a clarification question as well. This goes back, Kelly, to what you were saying about the laws around the junk fees are specific to the residents of that state, no matter where they go. So I think the question that's come up is, one of the states with fees, right? I think there was a question about fees. Kelly, I don't know if you've encountered this issue where someone's saying, in my state, it's not legal to assess this fee, and challenging that at the hotel. Have you encountered those as an issue?
So there are some hotel contracts that say that if a guest refuses to pay a mandatory fee, the group will pay it. So we have seen some of that language in hotel contracts because it is part of the obligation for the room block. So if the guest doesn't pay it, the group should. I have not seen an individual guest come across my desk saying that we've violated the law as long as we've done our mandatory disclosures the way we're supposed to. So to Joan's point, I don't think I have seen that particular occurrence yet. Most of these, you're going to have an attorney general that's going to be coming after you for a violation.
And that's a it's
I guess
definitely
let's go into the questions.
Point. And that's it's an important point. Attorney generals across the U.S., those are consumer protection advocates, right? And so this is something that consumers get their arms around, these junk fees, and so you could expect that.
Right. Although sometimes there might be a private cause of action. It just depends on the state.
Excellent. All right.
Okay. So what's our...
For the sake of time, we're going to jump to some of the questions that we received in advance of the webinar. The first question that we have today is for RFPs. So when you're building, creating, sending a request for proposal, what are the most valuable provisions to include?
I'll start here. It's the MVPs of the RFPs. The question was a great question that was asked. And if I had to sum up my perspective from the group side, I would say make it easy for the hotel to do business with you. And that starts with the RFP. Remember, an RFP is an invitation to make an offer. The offer becomes the contract that comes back to the client. But you want your business to be attractive. So you want your RFP to package, if you will, all of the information and data that you know the hotels will be looking for, specifically about where you've met before and your pickup and so forth. When it comes to contractual clauses, if it is an absolute deal breaker clause, you got to put it in there. And, earlier we mentioned about commissions. If it's going to be commissionable rate or non-commissionable, you want to put that in there too. But sometimes for groups, it isn't that it has to be a particular clause that has to look exactly this way. Instead, it has to be more that it's issue focused or concern focused, meaning we are looking for a contract with attrition, at if we have 80% pickup or less, right? So we're looking for a contract which would give us flexibility to reduce our room block or whatever the case may be. All of those issue focused things, I think, are also important to put in an RFP. But understanding, and I'll, before I toss it over to you, Kelly, I'll just say groups understand that hotels are strapped in terms of labor and review for these RFPs. So that precious piece of paper, whether it's a physical paper, electronic paper, becomes critically important. And again, from the group's perspective, Kelly, I've always said to my clients, make it easy to do business with your group. So when the hotels pick up these RFPs, they're more inclined to respond.
Yeah, and I'm going to refer back to our code of conduct discussion. So for the hotel's perspective, yes, I need to know what the critical clauses are for you so we can know at a threshold whether or not we're going to even be able to come to terms. But the other thing is, and I referenced this code of conduct from before, I didn't learn about that code of conduct until I got an attachment to go to our contract, which had some terms and conditions, and then buried within the terms and conditions was the link to the code of conduct. So in my mind, not only should have the terms and conditions been provided during the RFP phase, but an acknowledgement, even if it's, and by the way, we also required these, and here's the link for the code of conduct. That probably would have saved everyone a lot of time up front, and we probably would have taken a different approach all along and not wasted everybody's time. But I'm telling you that all those things that there's an expectation of on your side should be shared with the very first piece of paper.
Well said. Thank you, Kelly. Let's
All right.
well said. The next question here.
And I'll just add, Sean, that I know the HopSkip platform has an RFP tool built into that. I know that we've talked in the past about how, you've structured things to sort of package that important information to make it easy.
Brilliant. Thank you. I should have said that myself. I appreciate it, Barbara. Yeah. So HopSkip does have the ability for planners to be able to create contract clause libraries, and then including those contract clauses in RFPs is as simple as clicking a couple buttons. So that allows you to be able to communicate that contract language request up front and walk into the contracting phase stress-free. With that being said, let's go to the next question. And it entails what should planners be aware of when it comes to privacy and data clauses. What are some of the do's and what are some of the don'ts? Barbara, do you want to kick that off?
Sure. So lots of questions always around data disclosures. Kelly gave a great example when it came to that code of conduct. It had a bucket, if you will, regarding data. The biggest thing that I see coming across from the group side is, in some cases, a lack of understanding as to what consent that the group has received from the conference attendee to share their data. And Kelly mentioned earlier about the audit, even in that aspect of it. So when this question comes up in a hotel contract, in some cases, it already presumes, and the language actually often says this. In other words, it says that the group has the right to share the data. So the question back to the group is, do you have that right? And if you're saying yes to that question, where do you have that right? Is it built into your registration system process, etc.? So for all the planners on the call, just verify what consent you are procuring from your attendees and how it can be used. I had a client recently just had a conference and found out the week before that the attendee data was shared with an exhibitor as it had in the past. However, the consent had not been procured, right? The necessary scope of the consent to do so had not been procured from the attendees. So that exposes the group, and I know in turn, potentially not that particular example, but in the example of sharing data with the hotel could certainly impact the hotel. So that's first and foremost, I would say for planners. When it comes to the clause, you're already step 5, and you should go back to step 1 and make sure you have that. The second thing I'll alert you to is there are more and more states that have health data privacy laws. So it isn't just personal data, which by the way is a very, very broad definition, but it's also health data. And this isn't a HIPAA issue. So the HIPAA laws are governed to or forced to comply with healthcare providers. Those are those that are required to comply. Of course, absent some other circumstance, are not the healthcare provider. So health data. So we'd say, well, how does health data come into the meeting setting? Well, it can come into the meeting setting because if part of my registration process is to say, do I have a food allergy? And I say yes and give information. Food allergies can be considered certainly health data privacy. And now the group's collected that information. Obviously, the group is collecting the information to help comply and so forth. But what is the group doing with that health information? Has the person, which is usually required, and there are a couple states already that have adopted these: California, Washington State, Virginia, and Colorado. And what it requires at the time a question might be asked to where health data might be elicited or solicited, requested, is a consent specific to the health data. So that's one thing also, again, for groups to look at in their registration process. But the other thing is on the back end, when the information has been collected, how is it secured? How is it stored? How is it managed, et cetera? Because often in that data piece is important. So again, I go back and say with this question, from the group's perspective, it's often more about what the group is doing overall on its data compliance program and what it can do at the point of registration for its meetings and events than it is the language in the hotel contracts. Because I know Kelly, on the hotel side, when a guest checks in individually at the hotel is going to seek that guest's consent or permission to share their data. In other words, they're going to establish a direct relationship with that guest. Is that correct?
So yes, all the data privacy policies are online. And when a guest makes a reservation through the hotel, whether that comes through a direct reservation or at check-in when someone who was identified on a rooming list checks into the hotel, they have adopted and agreed to the hotel's data privacy policies. And the hotel then becomes the owner of that personal identifiable information data, the PII, and that we treat that data in accordance with our policies. Many of you may represent or be affiliated with corporations that want you to come and attach a data privacy policy to the hotel contract. I've also, by the way, that should be addressed in the RFP phase. But if they do want to attach a data privacy addendum to the hotel contract, just know that the hotel is not a processor. It is a controller. And so there are different rules that apply to someone that is, for example, holding your data through like a cloud versus someone who is processing, and that's a processor, versus someone that's holding your data as a controller. So have those conversations up front with your technology team so that you're communicating the right type of attachment to put on the hotel contract that the hotel will have to review. The other thing I want to bring out is I do have groups that come to me and say they want us to strip from our reservation system any of the names and the contact information and other data that we have collected on your attendees. And most hotels will not do that. Most hotels can't do that. Moreover, we have internal policies to keep records under certain laws about who stayed in our guest rooms and things of that nature. So we have to maintain it. But more importantly, that guest has independently given us the right to it when they stayed. So that's my 2 cents on privacy for now. I know we could spend an hour just on privacy alone. And I don't want to bore you with that nuanced stuff. But I think you and I have hit on the basics.
Absolutely.
segue.
Yeah.
Sorry,
And I'll just add that on those terms that Kelly mentioned, controller and processor, those are terms of art. In other words, are defined. The controller is the party sort of who owns the data, not the individual, but the person who's collected the data or the entity. And the processor is the person that you give the ball to and they go do something with it. So to Kelly's point, always kind of understand as well what role you're playing. I think that becomes important as well. I know one of the questions that we got in shifting gears here is just some general legal trends that we're seeing in group sales contracts that both hotels and groups should be preparing for. And I'll just start by saying I think this is a message that I give probably every day to myself and to clients, and that is hope for the best, but plan for the worst. And when it comes to your meetings and events, whether things are going well now or not going well, or you're unsure, the hotel contract, the group sales contracts need to reflect that possibility. So just as we were speaking of earlier, knowing where all the exits are, the hotel contracts need to address cancellation, even if you tell me there's no way we're going to cancel. The hotel contracts need to address what will happen if we have reduced attendance, even if you tell me, no, we're never going to have reduced attendance. And of course, the list goes on. So going into a contract negotiation from the group's perspective, hoping for the best, planning for the worst. That's first of all. Now, I know planning for the worst is that negative cloud or connotation with it. But the other way to look at that planning is really the flexibility. So the trend, certainly in hotel contracts across many clauses, is flexibility, whether it comes to the room block itself and adjustments there, to potentially the rates, to the meeting and function space, whatever the case may be, even the food and beverage minimums. If there's flexibility needed, that's put into the hotel contract. The other legal trend I'm seeing is probably as much of a business trend than a legal trend, and that is all the tightening. There has been tightening around the financial terms of the group sales contracts. So everything from deposits to credit approval to payment disputes, credit card surcharge fees, surcharge fees on turning BEOs in late and so forth. All of the financial implications coming out of a hotel contract, they've changed, they've evolved. And from the group's perspective, the group should absolutely get a handle on all of those fees, all those financial terms well before the contract is signed, and make sure they're going through all that and negotiating and firming everything up ahead of the contract being signed. Because of course, once the contract's signed, it's only a request made later, right? It's not going to be a legal obligation. So it's really important, again, and in addition to the hoping for the best, planning for the worst, is really understanding all the financial implications around that particular sales contract and making sure that those terms are acceptable to the group. Kelly?
So we've seen a lot of evolution, and it always is an evolution of the force majeure clause. Whether we've seen groups try to add pandemic or epidemic, or, let me go back 20 years and it was swine flu. And, so that clause is always evolving. As everyone on this call, I'm sure knows, there is a force majeure provision in state law. And even without a force majeure clause, there is a protection under state law. But our industry is different in that it's evolved what I'm going to consider a clause that started as a force majeure clause, and it's morphed into something completely different, but that's what we all call it. The thing that I'm seeing most often now, and for those of you who are super familiar with the force majeure clause, it's something bad happens, war, thunderstorm, something bad happens. That's prong one. And then the second prong that makes it illegal or impossible, and then you negotiate if you want something beyond that. for the event to happen, the services to be performed, whatever. I've had some groups leaving out the second prong. So it's just something bad happens. Well, that's not a force majeure. That just means there's an occurrence, right? And that occurrence may and shouldn't necessarily always impact your meeting. So if you have in-house counsel that is suggested that you present a clause that lacks a second prong, I will tell you, those are the types of things that I stop and we redo, because that is not, in my mind, a proper force majeure clause. And it's also not the measure of being able to terminate the contract that I think is appropriate. The other thing we're seeing quite a bit of on the force majeure side is I'm going to call it current events. So long TSA line outs, that's not going to happen. ICE raids in the city outs, that's not going to happen. Those are not triggers for a force majeure clause in a hotel contract, in my personal viewpoint. So those are the things we're seeing in force majeure clauses that creative minds are putting forth. So Barbara, I know you and I talked about some of those. Were there any of those you wanted to add?
Absolutely, Kelly. I think anytime we have a chance to kind of highlight the two prongs that you've mentioned, I think it's important. On the first prong, the so-called grocery list of the bad things. Yes, I agree that current events have been prompting groups to want to make that grocery list more detailed and pull in current events and so forth. Before you do that, again, certainly talk to your legal eagle. From my standpoint, what saved many a group is the catch-all phrase at the beginning or the end of the grocery list. Like when you go to the grocery store, you probably have things on your list, you buy other things. It's the including but not limited to bread, eggs, milk, etc. And that catch-all phrase is important because certainly if you can establish something happened beyond the party's control, that could certainly be sufficient, again, depending on the clause. So that's the first prong. The second prong, and it's interesting to me, Kelly, when you mentioned to me in discussing the session ahead that there were groups that were kind of coming to the table without a second prong. That's a head scratcher for me because I look at force majeure clauses as an opportunity for the parties to negotiate a business arrangement. And part of that negotiation around a business arrangement, if this contingency happens, is what's the fix? What's the remedy? What happens next, right? And when that's not there, it leaves it open. Now, maybe to your point, as you were sharing with me, Kelly, that's the strategy on behalf of perhaps some lawyers representing on the group side. But I'm hard pressed to kind of think how that does a benefit or a value to the group. Again, not challenging if your legal eagle said that. Certainly, they probably have their own position. But from my standpoint, the clause, which you've described rightly so, Kelly, evolution from what might have been codified in state law or established in case law in a state, down to what the parties can negotiate again as a business term contract. This is absolutely everybody's opportunity to do so. Hope for the best, plan for the worst. So the second prong should be, in addition, as you mentioned, standard, illegal, impossible. The bar, if you will, the second prong should be set at a level that both parties can accept. So whether that's commercially impracticable or some other standard, it should be in there. So I agree. I think emphasizing those two pieces of the prong. The other thing we see, Kelly, again, it goes back, I know you probably see this. What if force majeure applies, but I don't want to cancel my event, which of course happens a lot. And, both parties certainly benefit from the event continuing. But of course, then we might talk about, well, there's 50% pickup. What's going to happen for attrition and food and beverage minimums and so forth. Again, whether there's language in the contract for the group to hang their hat on to say they should be excused or those should be proportionally reduced, that's a negotiation point. But on the back end, if your contract doesn't have that and you're facing this issue, that's a conversation with the hotel. Make the ask, have the conversation sooner than later ahead of your event so that both parties can mitigate any potential fallout from what might happen. Again, both parties are wired. We know, Kelly, the hotel rooms last night, are a perishable commodity. They're right?
Yep.
So it becomes important from the hotel's perspective too.
Absolutely. All right. I think we have time for our last poll.
We're gonna post it now. Yeah. So guys, we want to know what topic did you get the biggest takeaways from? Your feedback helps fuel our next webinar. So we would love to get your input on what you found most valuable today. And the polls should be in front of you now. And with that being said, I'd like to thank Barbara and Kelly again for a great webinar. We know there was a little bit of audio issues throughout, so we'll make sure we'll get that either cleaned up or some certain parts re-recorded. But again, great engagement. Thank you everyone for your attendance, and we'll see you at the next one. Thanks, guys.
Thank you.